Okay, everybody. Apologize for the short delay. I am Eric Finch. I work for Boundless Immigration. I'm a former USCIS USCIS adjudicator and a former Department of State consular officer. And I'm here to talk a little bit about some questions that were submitted today and give my personal thoughts on some of the immigration issues that people are experiencing. Just want to remind everybody that I'm not a lawyer. None of the advice that I'm giving today is legal advice. And if you have questions specific to your immigration case, I do recommend that you seek the help of an immigration legal professional. All right, so I've done a few of these. I think some of the folks who are joining us again may have remember how these usually go. We had some questions that were submitted ahead of time that I will try to work through and talk about. Along the way, anybody who has questions that come up during the discussion, feel free to shoot those to our account here. And my colleague and I will work together to get those questions teed up and answered as well. And I think we have, let's see how much time we have blocked off today. Yeah, we got about 45 minutes today, so I think we will have plenty of time to talk through some of these more challenging ideas and questions. Okay, so let's go ahead and get started. First question, and I think we may have talked about this one before. Can a congressperson help us with cases for unanswered inquiries or requests? So, yeah, this is a question that we get a lot, right? You prepared your paperwork, you submitted everything to USCIS, and now you play the waiting game. And for some people, that can stretch out from months to years. And in the interim, you're eager for more information, status updates. You want to see when your biometric appointment will be requested. You want to see when the, like predicted wait times for interviews will be at the field office or consulate where you're going to complete your immigration process. Yes. And, during that process, people send inquiries to USCIS in most cases, sometimes to the Department of State, embassy or consulate, if that's where you're going to be interviewing eventually. And, people don't get the information that they're looking for. They get a sort of a boilerplate response. They get no response. They're not even able to connect with the person that can give them the status update in the first place. So, given that these are federal agencies, people's natural reaction is, can I work with my congressperson or senator, to put some pressure on that agency to do their job, essentially. And that's a very reasonable way to approach it. Most U.S. politicians have a constituent services office. They are obligated and in many cases more than willing to support their constituents. And let's keep in mind that those constituents are American citizens in most cases, sometimes green card holders. And those people, are elected by American citizens, and if the American citizen in question is a person who's trying to get their spouse or their parent or some other relative into the United States from overseas via this immigration process, then it stands to reason that that politician should be able to help with that process. Now, in actual practice, I would say it's not a bad thing or really anything that you should avoid in terms of like reaching out to these politicians for help. I think, just to manage expectations properly, they're limited in what they can do, right? I mean, yes, they have oversight, technically, and they can convene hearings and question high-level USCIS officials, but their ability to intercede on any individual case is somewhat limited because of things like the Privacy Act, where, even if you authorize that senator or one of their staffers to reach out on your behalf, in which they will ask for your permission to do, the agency can say that's, sort of protected information that is involved in a process that, requires a higher level of clearance for you to get more information about. Or they can just basically say, hey, we're working on it. We'll update you when we have something new to share. And, then they can sit on it for months or years. And from their perspective, they don't have anything to share. So I guess in a nutshell, the answer is there's no downside. A lot of people are concerned about doing this because they're worried that the agency will retaliate against them for causing, that inquiry from the political official. I tell you that that's not allowed, and there's no possible way, and it's actually illegal for the agency to retaliate against anybody for that type of activity. So I don't want people to worry about that. But also, like I said, you should be aware that it could have some positive effect. but it'll be hard to know, and it won't really be something that will be effective in every case. So, yeah, I think that's it's an important thing to think about. For a lot of things, aspects of American life is, what are the politicians doing to support me here, and how can they more effectively exercise oversight over these agencies? And I will say one other thing before I move on to the next question. I said there's no downside, and I don't think there is. And I think even if that politician is not able to help with your individual case, it is important to make them aware that something is not working well in the federal government. That can change their perspective and their approach for future hearings and inquiries and things that they do on a larger level that could potentially, cause positive change in larger positive change in the system. So it's definitely good to surface that and make your representatives aware that you're having these challenges and you feel like the agency is not functioning properly. Okay, next one. There's a question about, will being pregnant hinder my chances of getting a K-1 visa to move from Canada to the USA? Well, not to be cheeky, but it kind of depends on who the father or mother, the parents of the baby, right? If you were pregnant with somebody's child and that was not the fiancé that you were going to immigrate to the U.S. with the intention to marry, I think the officials might have some questions about that. Now, there's nothing wrong with that, and we know life happens and doesn't necessarily mean anything negative about you or your situation. But, it would probably raise some questions for the consular officer, the embassy official, about whether the relationship that you're currently entering into is legitimate. So again, not a deal breaker, but you would want to be able to talk about that and explain, what's going on and how your life is progressing in your relationships. If you're saying pregnant with the child of the person that you're immigrating to the U.S. to marry, then yeah, that's no problem at all. In fact, it would probably actually help your case because it shows evidence that you're in a relationship with that person with an intent to establish a long-term relationship. So no, but writ large, probably no real impact as long as you are able to discuss the situation, in a truthful manner with the consular officer during your interview. And then, yeah, there's a larger question here around what is going on with the status of the child. If the child is born abroad before you can travel into the United States to, perform the marriage, I've had people ask questions like, well, what happens to the status of the child? Now, again, if the child is the genetic child of the U.S. citizen who's petitioning, it is still possible for that child to be a U.S. citizen at that time. You just have to go through a separate process at the consulate to obtain what they call a consular report of birth abroad. And then, of course, if the child's born in the U.S., under all circumstances, they become U.S. citizens in that case. So no problem there. And if people have other questions about consular reports of birth abroad and how to qualify for those and what the restrictions are, happy to talk about that in a separate question. But I don't want to take up valuable time if people are not interested in that point. Okay, so that was pregnancy during the K-1 visa process. Next question is, what is the definition of processing times? Okay, this is a good question because I think this word gets thrown around a lot. From the perspective of the U.S. government agencies involved in the immigration process, processing time is the time it takes for them to navigate that application through their internal process, which, okay, that sounds kind of obvious, but so that wouldn't normally be something that we were too worried about, except that the actual processing times for many immigration applications exceed 8 to 12 months on their own. It just takes that long, even if you don't have to wait, even if there's no backlog, even if you just submit it and you were the only person in the whole system and they just had one application that had to go from start to finish. It still takes about 8 to 12 months just to have the thing go through the normal process that every application goes through. Now, processing times in this scenario would include the time it takes for the National Visa Center to prepare your case and schedule your interview overseas. And then outside of processing times, there's all kinds of other things that can happen, right? There's individual backlogs at embassies and consulates or field offices in the U.S. where they just have that many cases in line that it takes months and months and months extra to get to the actual interview for your case. There are security checks. There's fraud detection investigations that are considered to be outside processing time and are sort of clocked and logged in a different format. There's the time it takes to actually print the visas, which is usually pretty short. And yeah, and then I think the biggest thing that people can get confused with when it comes to processing times is the fact that for a lot of preference-based categories, there's also a currency date or a priority date, right? And that is the time that you have to wait before you can actually file for the visa or adjustment of status. So, I can look at the visa bulletin, but say, your preference-based category, like say you're the spouse of a green card holder. You're at this moment you're current, so you have no wait except for the time it takes for you to actually file and process the case. But for like an F2B, for example, so if you have a son or daughter who's over 21, yeah, you have to wait, like usually around 3 or 4 years from the time you file the petition, the I-130, to the time that you actually get permission to go and apply for that visa. And then processing time starts. So you wait and then you file. And then, if say you're going to apply overseas at a consulate, you waited 3.5 years, and then you got permission, because your case became current, your priority date matches the date on the visa bulletin. Now you can apply for your DS-260 and do the things that you need to do to get your immigrant visa interview scheduled. That may itself take several months, which is, again, what they call the processing time. So, yeah, in a nutshell, processing time is the time from the time you submit the paperwork to the time you actually get your interview and get your visa or green card printed, not including any things that happen around the edges or separate investigations or things that involve like preference categories and priority dates. That is what is considered processing time. Okay, next one. There's a question. My fiancé is incarcerated. Can I use Boundless or should I go with a lawyer? Whew, these are tough. Generally speaking, at Boundless, we don't deal with folks who have significant criminal issues because it's quite complicated, and we feel that immigration lawyers are the best parties to properly advise and guide people through the process when they have those issues. It's not clear from the question whether the fiancé is the potential beneficiary or the potential immigrant or the American citizen involved or the green card holder that's involved in the case. In both cases, it's going to complicate the immigration process in somewhat different ways. Generally speaking, from the point of view of the potential immigrant, again, if you're incarcerated, I'm assuming, that there was some somewhat significant criminal matter involved in the decision to land you in jail. Then there's things in immigration law called ineligibilities, where they're going to look at the nature of the crime and the time that you were in jail, and how old you are, and what other things that are there in your immigration history, and they're going to decide whether you're even eligible for that immigration benefit. And if they decide that you're not, you may have to pursue a waiver process or go through some additional steps to prove that the not granting you that immigration benefit is going to cause what they call exceptional hardship to the usually U.S. citizen petitioner. If it is the petitioner themselves who's incarcerated, I think it's not necessarily going to make or break the case, but logistically it's going to be quite difficult for a prison inmate to effectively prosecute this, process that we know is quite complicated, provide the proper paperwork and do all the steps that they need to do. And then there are certain crimes that American citizens can commit that can cause issues in the immigration process around, concern about sexual offenses or things related to children. So that would be something that a lawyer would really need to know and help the people involved understand. So yeah, I would say in a case that involves one or both parties being incarcerated, an immigration lawyer, perhaps even a specialist immigration lawyer in that particular type of case, would be the right place to start. Okay. We have a good citizenship interview question. So, how should I prep for a citizenship interview? Anything I should watch out for? The citizenship interview, when I was working at USCIS, I did quite a few of these, what they call N400 citizenship interviews. And I think they have mainly three main components, right? And there's a couple of things to watch out for. There's the portion about the citizenship test, which involves some basic U.S. history, and government questions, and then some short like English reading and writing exercises. There are plenty of resources online where you can prepare for that part. The questions are public knowledge. You won't be asked all. I think there's like 120 questions that they can ask. Usually they just ask 10, or there was a little bit of time a year or two ago where they turn that to 20. But generally people who take the time to kind of like do some flashcards or work on that part of it are able to get the history questions. And then, a lot of people don't know this, but English language reading and writing skill, in addition to speaking and understanding English, is a requirement for the naturalization process for most people. There are some people who can seek a waiver of that for medical reasons. So, I think that's something that could be very challenging for folks who immigrated, in the middle or late in life, who haven't had the opportunity to expand their English language abilities and things. And, the agency has done some work, I think, to try to reach out to the communities that, especially like folks like refugees and asylees, who are kind of most affected by this. And there's some resources out there, but it can be a challenge. So that's kind of like phase one of the thing. Now, phase two of the interview will be about this question of saying and agreeing to certain things that are involved in like becoming an American citizen. So they'll ask you a bunch of questions about, these similar to what they did during the green card process, just to make sure that there's no like sort of criminal or national security related issues with your case. And if they do find those things, they'll explore that with you and try to understand like what has occurred. I think we've talked in this setting before about the statutory period. They're going to look at, the time period that running up, the 5 or in some cases 3 years for married folks that led up to your N-400 application, and see what, if there's any criminal history there. And if there is, they're going to have to understand and like make a decision about whether the standard is met in terms of like good moral character. And that's another one that we can explore in more detail if people are interested. But, in short, they're going to look at those crimes and say, is this indicative of a person who has, an upstanding moral character, is like community oriented. They'll weigh different things in your past. So, they'll look at these criminal matters, and then they'll say, have you been doing things to offset this, like getting involved in your community outreach organizations, or, doing volunteer work, and just try to, it seems like a little bit of an antiquated concept, but they're trying to make a good judgment about whether you're, the type of citizen that our country needs, and whether you can, perform the duties of a U.S. citizen effectively, and, how your history speaks to that. So I know that's a little nebulous in practice. It just really involves like them kind of like talking a little bit about what you've been doing over the last few years, and trying to understand like what type of activities that you're involved in, and people that you're supporting, what your family situation is like, and things like that. And then finally, they get to the oath portion. Everybody has to take an oath of citizenship. Again, it's another one that you can find online. It's not a long oath, but it has some difficult vocabulary in there. There's some areas that if people have religious reasons that they object to, the oath talks about bearing arms on behalf of the U.S. In a sense, being a soldier for the U.S. if needed. Some people object to that for religious or moral reasons, and in that case, you can discuss with the officer how to remove the portions of the oath that you feel are not applicable to your situation, and they'll discuss with you like the process to do that. And then once your version of the oath is finalized and you have overcome the other parts of the application, then they go ahead and will conclude the interview, approve the case, and they'll get you scheduled for a naturalization ceremony where you'll stand in a group of people new to be American citizens, and you'll do that oath that you agreed to take, and then you get your certificate of citizenship, and you're good to go. You never have to deal with immigration again. So yeah, great. For most people, the naturalization process is pretty straightforward. You've been in the U.S. for a while. If there's no major hiccups in your case along the lines that I talked about, and you're able to pass the test successfully, then you'll get that certificate. You can go apply for a U.S. passport after that, and then you're good to go. So had a couple questions come in, so I'll take a quick detour into a few of those. There is a question, if I qualify for temporary protected status, is it possible for me to apply for asylum? Oh, these are complicated questions. Fundamentally, the answer would probably be yes. They're kind of treated in two different ways, right? Like TPS would be a function of your nationality and whether you're in the U.S., and TPS also doesn't really confer a status on you except to just give you like permission to stay and work in the U.S. So the asylum application in that scenario would be something that, like, if you have a proper asylum claim, then they judge it to be valid, and you're able to go through it. Again, if you're applying for temporary protected status, my assumption is that you're already in the U.S., right? And therefore, that's not necessarily always the case, and there are people who can apply from abroad, but like that would be important in this context because when it comes to an asylum claim, there's affirmative and then sort of defensive asylum claims, right? Where in most cases, people who walk up to the border and put their hands up and say, I want asylum to a U.S. Customs and Border Patrol officer, like that's an affirmative asylum claim, and then you get a credible fear interview, and then you get a court date, and they look at your claim and all the information that you submit at that time. For defensive, there's folks that are already in the U.S. and then they say, well, because I'm running out of time on my visa or something's happened in my country during the time I've been in the States, like I can no longer go back. That's one where it sort of like applies to the, you can file that and get that looked at in immigration court while you stay in the U.S. on, in some kind of status there. And it's possible for the two things to kind of be happening at the same time. Not all countries and nationalities qualify for TPS, so it would be an option for some and not for others. But yeah, if you feel you have a valid asylum claim, it is possible to go ahead and begin that process, and also on a separate track, get your TPS approved, based on the qualifications and programs that are in effect at the time that you're there. Another one is, these are common questions that we get. Can I use my B1, B2 tourist visa to visit the United States if I have a I-140 EB1 petition? That's an employment-based, immigrant visa petition pending. This is one even I think a lot of lawyers have trouble drilling down on the right question for. I think the best way to kind of talk about that is to think about it like this: like B1, B2 is a non-immigrant visa, and if you filed a immigrant visa petition, that clearly shows that you have immigrant intent. And one of the requirements to get a B1, B2 visa, or really any non-immigrant visa, is that you don't demonstrate immigrant intent. The assumption is that all folks who want to get these B1, B2 visas would use them to enter and stay in the United States if they could, and that's why they have an interview where they're basically ask you to convince the consular officer that that is not your intent. So in this scenario, let's think about it more realistically. It's possible some of these B1, B2 visas last for 10 years. What if you applied for one and then 5 years later you got a great job offer and a sponsor in the U.S. and they want to begin this immigration process? That itself can take quite a while, right? And it's why should you be all of a sudden restricted from using the visa that you already have just because, you have an employer who's working to get you a green card? So in practice, it doesn't instantly invalidate your B1, B2 visa, and there's a lot of reasons why you might want to visit in the meantime, right? Like maybe you have a friend that you want to go hang out with, or, you have some other, conference that you need to attend. And I think for a lot of people, they are able to continue to travel during that petition pending period. For folks who have preference-based cases, including an EB1, you may have a currency date that, means that it'll be 5 or 10 years before you can actually get that green card. And it's it's a little silly that you wouldn't be able to travel to the U.S. at all in the interim. So I'll kind of caveat, I'll say that there's no hard and fast rule. It does happen. People are able to travel that way. There's an element of randomness to it because the person that's going to decide whether that visa and that trip is permissible is the CBP officer at the port of entry. So if you fly from your home country to the U.S. and you enter and you say, they look at the records that they have on their computer when you go through customs and they say, oh, you're applying for a green card. You would want to be able to respond to that and say yes, I am. And in this case, I have some other, limited plans for this trip. I'm going to be here for a week to visit my cousin or something like that. And then I'm going to return to my country and wait for my petition to process and wait for my opportunity to get that green card the right way. At that point, the CBP officer has the authority to say, no, I'm not letting you in. you need to wait until you can get your green card, or, okay, that's fine. Here's the amount of time that we'll give you, and with the expectation that you'll visit the United States as agreed for that trip, and then leave, and take whatever time it takes to get the green card processed and ready for your interview overseas. So yeah, I guess that's kind of top level, like how it works. Like there's some risk involved. There are things that could happen or issues that could arise that would cause the CBP officer to say like they're not comfortable with like admitting you as a tourist when you have that status pending. But the best thing you could do is just be honest about what's happening and be clear about your intent during that trip, and it'll somewhat be left up to the CBP officer's decision there about whether they view that as an acceptable use of your tourist visa in that potentially have an immigration petition pending scenario. Okay, and there was a question. My husband and I didn't have a wedding yet because we are still saving. Would that affect the green card process and interview process? If you have a legal marriage, which means legal in the place that the marriage was performed, and it's legally recognized by that government or entity or local authority, then that is all you need to apply for an immigration benefit. If you have that marriage has been performed and it's legally recognized and you have that paperwork, then you can go ahead. And, again, so from the eyes of the law and from the eyes of the U.S. federal government and USCIS, that's all you need. Now, there is a thing that happens where, around the edges of these cases, like they're going to look and see, like, do we believe this relationship is a true relationship? Can we verify that? And one of the ways that is done in many cases is like talking about your wedding. Like, people who are married, like the assumption is they had some kind of ceremony or some kind of recognition of that event. It's not true in all cases. Like for me personally, like I had my wedding, with my wife several months after our actually like legal marriage because I had to start the green card process for her. And, we couldn't wait till the perfect date for our family and everything to do the big ceremony and everything. So we just went to the courthouse and got the paperwork done so we could start that process. And then we had the nice ceremony that we wanted to have, later. So yeah, I think a lot of people do that. It might come up in your interview, or, there's sometimes like, oh, did you have a wedding event? And they would only be asking because, that would be normally the expectation is that folks who are married do have a ceremony. But, you could certainly say what the person in the question said, like, hey, we want to do this right, and we have to save up money, and, we have this plan. Or maybe even some people are like, we don't believe in that. We don't want to have a big ceremony. It's just me and my spouse, and the only people that we need to, know that we're married is us. That's fine too. So yeah, I think generally you're probably fine if you haven't had like any kind of ceremony or anything, and you would just want to be able to talk about that with the officer if they asked you some questions about that, and as long as they believe that your relationship is legitimate in spite of the lack of a ceremony, you're not going to have any problems. Okay, we are running out of time. We got time for one more question. I will grab this. There was a couple we didn't get to here. Okay, this is an easy one. So there's a question: how long does it take after your biometrics appointment to get your work authorization? This one is kind of a moving target. Like usually you get your biometrics appointment like not too long after you file. You'll get your acceptance notice, and then that'll be the next thing that comes within a month or two. And then I believe the work authorization EAD and the advanced parole cards usually come about 5 to 7 months after filing. So you would probably get your acceptance notice within a month, and then another month or two after that, you get your biometrics appointment. Biometrics appointment is completed, and then wait another like 6 to 8 weeks for the EAD and advanced parole card. Sometimes it's a combo card, and then several months, maybe years, until you get your actual interview and your green card. Okay, so hopefully that's helpful. And then the last one I had, there's a question: the CR1 backlog. Is there any light at the end of the tunnel? So this is immediate relative spouse filings overseas, and we all know that there's a significant backlog there due to COVID and other general reasons that have occurred over the last few years. and the questioner is asking, like, are we going to resolve this anytime soon? So one thing we do at Boundless is we keep an eye on immigration-related news, and the National Visa Center has begun. So National Visa Center is part of the Department of State, where the approved petitions from USCIS arrive with information about the beneficiaries who are overseas, and then some documents are collected, and the information is forwarded to the appropriate embassy, where they begin the process of scheduling you for a visa interview. Now, under normal circumstances, like, that part would be very quick, right? Like, it just, the NVC gets a few documents from you, they kick the information to the consulate, and then the consulate, if they have a, like in the days before COVID, many of them probably only had a few weeks wait time before they were able to bring you in for your interview, get your visa printed, and then get you on your way to the States. Now, a lot of the embassies and consulates around the world were shut down for huge swaths of time during COVID. And that includes some of the U.S. Domestic, facilities for the Department of State. And as a result of that, the National Visa Center has begun, as of feel like late 2020 to currently, the National Visa Center on the travel.state.gov website will publish a list of wait times every month. And the bad news, striking at this question, is they really haven't made a lot of progress reducing the backlog over the last 12 to 18 months that we have been keeping an eye on it. And there's a couple of reasons for that. One, even as they sort of take care of the oldest cases, and they usually do about 30 to 40,000 interviews a month, across the world. There's always another 40 to 50,000 that are getting dropped back into the pipeline as new applicants. So they're working from old to new, and they're not quite able to, it doesn't seem like they're quite able to find enough manpower to move that needle to the point where the number that are going out are bigger than the number coming in. So even as people are actually, there are people, about the backlog, has hovered around 500,000 cases. I think it may be down to like 400,000 now, but, they're not really getting through more than about 5 or 10% of that every month. So if you think about that in terms of long term, that means that this backlog will probably continue to exist for the next decade. And that, it will vary by consulate and embassy, and hopefully they're able to staff up as the world opens again. But, so I guess my answer would be no, there's really not any light at the end of the tunnel, unless Department of State completely changes their approach and does things like, start doing interview waivers, or, bring on significant number of temporary personnel, or reshift their priorities to attack this backlog more aggressively. You'll continue to see long wait times and backlogs for all CR1 and overseas applications. Okay, I think we're at time. Thank you for joining me. It's been really interesting for me to hear these questions and think about the right way to approach these topics in a way that's helpful for the folks on the call and for our community here at Boundless. So thank you all for your submissions. I enjoy doing these talks. This one we ran a little longer, and it feels like we still had a lot to talk about. So I'll work with the team here and see what we can do to get the tempo on these Q&As a little more frequent. And as long as you guys keep sending questions, I'll keep knocking them out. So thanks for your participation, and I'll see you next time.